Yes, Mr. Waite.
My Lord, we'll finish briefly dealing with Mr. Hussain. Mr. Lee has just pointed out a particular passage we want to ensure the court has. It's page 35 of the core bundle in Hussain, which are the grounds of appeal. I believe before actually to the upper tribunal. The second paragraph on that page sets out the steps that were taken before the substantive determination to bring Judge Hanson's attention to the submissions of the second.
Yeah.
What I was in the process of doing, briefly, is setting out why the 2nd of April submissions added nothing to what was put in later. First, in relation to the 9th of April, which I've already dealt with, and secondly, in relation to the 16th of April. I say that what was put in on the 16th of April was a more detailed version, in effect, of what was lodged on the 2nd of April. It's rather a long process to take you through it. I can either do that or can just give references upon which I rely, which I think is going to be quicker.
Yes.
And just read them out. So
just read them out a bit louder than you're doing at the moment. Then
yes.
Write them down without your voice trailing away.
So paragraph 7.1 on page 7.4, which is the start of the submissions on the substantive merits, refers to failing to consider material matters or giving legally adequate reasons. And so an example of where that is developed in the 16th of April submissions is paragraph 31 on page 57, paragraph 34 on page 58, paragraph 7.2 of the April submissions attacks the finding that there was no significant new evidence, and it does so with reference to specific examples which are set out at 7.2a and b. I say that paragraph 7.2a is addressed in paragraphs 38 and 39 of the 16th of April submissions on page 59. Paragraph 72B in the 2nd of April submissions is all about the Habib bank receipts. I say that is replicated or developed in the 16th of April submissions in paragraphs 14 and 20. Paragraph 20 is on page 55 and paragraph 14 is on page 53. Paragraph 7.3 of the 2nd of April submissions challenges paragraph 39 in the FTJ's determination in terms of whether that paragraph is legible and comprehensive. Those points are repeated and developed in paragraphs 16, 17 and 20 of the 16th of April submissions, and that's on page 54. Paragraph 7.4 of the 2nd of April submissions challenging
Paragraph
7.4 challenges the rationality of the finding in paragraph 40 of the FTJ's determination. And that, I say, is the subject of detailed further argument in paragraphs 21 to 32 of the 16th of April submissions. And that's on pages 55 to 58. Paragraph 7.5 of the 2nd of April submissions challenges the findings in relation to the appellant's uncle's ledger or diary. That matter is the subject of paragraphs 33 to 36 of the 16th of April submissions, and they're on pages 58 to 59. Paragraph 7.6 challenges what is said to be a perverse finding in paragraph 7.6 of the 2nd of April submissions challenges a perverse finding in paragraph 41 of the FTJ's determination. And that point is replicated and developed at paragraphs 37 and 27 to 30 of the 16th of April submissions. 37 is on page 59. 27, 30 is on pages 56 to 57. Paragraph 7.7 deals with whether the FTJ made a sufficient finding on whether the appellant was a member of the sponsor's household, and that is addressed in paragraphs 46 to 47 of the 16th of April submissions, and that's on page 61. So, whilst I readily accept it would have been better for the upper tribunal judge to refer to the 2nd of April submission, in my submission it is easy to understand why he may have felt it unnecessary to do so, because they replicated what was put in later.
That must be on the basis that you're maintaining your submission that he read them.
Exactly, and I maintain that submission.
So your submission is that we should work on the basis that he didn't refer to them because he didn't need to, because everything he needed was in 16th of April.
9th and 16th.
Sorry.
And I say that despite the terms of the annex, if you put what was said in the ground of appeal in terms of subsequent service of the 2nd of April submissions, service of the 2nd of April submissions prior to the substantive determination. If you read that in conjunction with the upper tribunal judge's confirmation that he did in fact consider what was filed, you should legitimately infer that he considered. I also respectfully submit that it would be very surprising if he didn't, given how much they are referenced in the 16th of April submission. In terms of the substantive merits of the upper tribunal judge's decision, first of all, in relation to the determination of the case on the papers, it's very clear, I submit, that he applied no unlawful presumption. That's apparent both from his express reasons and his reference to the President's response to the ILPA letter, which makes clear that no such presumption should be applied. In relation to the challenge to the substantive merits of the upper tribunal judge's decision, I rely upon what I have set out in writing in the further submissions on this point, dated the 24th of January 2022. The key point in my submission is that the first-tier tribunal judge had to form a view based upon the reliability of the oral and documentary evidence. So she needed to form a view of the reliability of the appellant's oral and documentary evidence in the round, in deciding whether the appellant had discharged the burden of proving dependency. It is a simple case in my submission where she has weighed all relevant factors. She's considered the oral evidence, the documentary evidence, and she was simply unsatisfied as to its reliability, such that the relevant burden was not discharged. My learned friend talked about the diary or ledger, but what the first-tier judge was reflecting in my submission was a long-standing approach in immigration cases, whereby you assess what weight is to be attached to the evidence. There was no requirement upon her to make an express finding or to the effect that this was a forgery. The requirement was to assess the weight to be attached to the evidence that was reliable. So those are my submissions in relation to the case of Hussain.
Can I just ask a couple of questions, if that's all right? If the court considered that it was fair to have a paper determination generally, but this had turned into an unfair procedure because matters hadn't been taken into account, then would you accept that if there has been an unfair hearing, the remedy is to set aside that and remit it back to the upper tribunal to start again?
Yes.
Yeah. I'll check with what Mr. Lee's position is. It seems likely that to be common ground.
I think so, unless you were satisfied that we have taken the point in the respondent's notice that there was no material error in
below, yes, but and that our proceedings could cure fairness, as it were.
Exactly.
Yeah,
I
which
think
is a possible way of dealing with it.
I think Mr. Justice Swift used the phrase "it's beyond argument" or something like that.
Well, yes, but he was again in a different phase, in the same way that JCWI was different. That was for setting aside under Rule 43, whereas we're determining an appeal, as it were.
So, I mean, I think based upon what I say is...
Well, I mean, those matters, if we considered it unfair and remitted it back, those matters would be open to the Secretary of State to submit before the tribunal.
Yeah. But it would be open to you in my submission to conclude that any error of law by the...
Well, normally, if you have something that makes something unfair, normally you set it aside.
You do.
Rather than and give them everyone a fair opportunity, preserving.
That's why I think Mr. Justice Swift said that you do, unless he used the phrase "it's beyond argument."
Yeah. That
the result would have been the same. So, if you were satisfied that it was beyond argument, that the appeal would still have been dismissed, then I submit you should refuse.
Thank you.
In relation to the case of GA, it is accepted that in that particular case, the determination of the UTJ was to be quashed on an application of the principles in EP.
Sorry?
In GA.
No, you dropped your voice at the end.
I'm sorry.
Application of the principle in...
on the principles in EP.
EP.
So on an application of the principles in EP, which I would invite this court to uphold.
But again, we're sort of faced with a slightly different situation because that's a Rule 43 application. We're entertaining an appeal. If we consider that it's an unfair procedure, we're likely to take the same view and just quash it.
Exactly.
And then remit it.
Yes.
Yeah.
Yes.
And I think you accepted that it was unfair in that situation because there hadn't been an opportunity to deal with the change of country guidance, and that the upper tribunal judge had failed to engage with the 23rd of July submissions.
I accepted that it was unfair because she didn't consider whether it would be fair to hold determine the case on the papers, and she overlooked a request for an oral hearing. That's the basis.
Sorry,
Yeah.
overlooked a request.
A request for an oral hearing.
In the 23rd of July.
On the 23rd.
Yeah.
Yes.
Which just doesn't seem to have got to her. But,
Exactly.
I mean, for understandable reasons, given the pandemic.
But so the only issue in Gay is what happens next. I think my learned friend invites you to direct that there be, not just direct, I think, that there be an oral hearing, but determine whether there was an error of law in the first tier tribunal's determination.
Well, and that appeal is in front of us. And what do you say to her point about the country guidance? The upper tribunal judge relied on a change to country guidance, which wasn't actually an issue in the error of law proceedings.
I say that may be right. I don't formally concede it, but that may be right. But it's not going to help you in my respectful submission in relation to whether, because we've agreed that it falls to be quashed anyway.
Yeah.
It's got to be retaken anyway. That's not going to help you in deciding whether there was a material error of law in the first tier judge's determination.
Yeah.
And in my respectful submission, this is an absolute paradigm case of where the Court of Appeal should not attempt to decide that question, because it really can only be fair.
You're dropping your voice again,
Sorry.
Mr. Wade. I am finding it difficult. We've got aeroplanes outside. We had trundling carts this morning. So you've really got to shout at us.
I say that this is not an appropriate case for the Court of Appeal to decide whether there was a material error of law in the first tier tribunal's decision, because it would inevitably require you to consider matters which are more properly decided by a specialist tribunal. And I just want to illustrate what I mean by that with reference to a number of different points. It involves such questions as whether country guidance relating to the OLF can be applied to other opposition groups.
So whether the OLF can be applied to, in this case, the
PG7.
PG7.
Yeah. It involves the case as a whole interpretation of two sets of country guidance in relation to Ethiopia. One which is hot off the press, literally days, I think it's recently been promulgated.
So, which is the OLF decision and the one we looked at yesterday?
It's RAA.
Yeah. Thank you.
It also involves fact-specific matters which need to go back, or case-specific matters which need to go back to the upper tribunal to fairly decide. For example, GA's case, as I understand it, as articulated by my learned friend, is, well, the first tier judge didn't consider whether, despite rejecting my credibility, I would be at risk of persecution because I'd be required to suppress my political views. He also didn't properly consider, as I understand it, as part of their case, the sur place claim that based on activities in the UK. Now, if you look very briefly at the appellant's skeleton argument submitted before the first tier judge, and that is in GA's supplemental bundle.
Page.
That starts on page 4.
Sorry,
Page 4.
This is the Court of Appeal skeleton.
No, this is the skeleton argument which was lodged prior to the first tier tribunals. So it's page 4 of the supplemental bundle.
Yeah, I was in the wrong one. Thank you.
Now, from my reading of that document, which is quite lengthy, there is no reliance upon sur place activities. There is no suggestion that regardless of whether the account of past mistreatment is rejected, the first tier judge should consider an issue of suppression of political beliefs. None of those matters are raised. I say the issue of whether the first tier judge...
Is that fair? Look at paragraph 12 at the top of page 5. The appellant has continued his anti-government activities in the UK. You're quite right that he says he did lots of things in Ethiopia which he was disbelieved about. But he was believed that he was a PG7 supporter, and at the top it says continued anti-government activities in the UK.
Sorry, my lord, which
Page 5 at the top.
Page 5.
Seven of the electronic.
Yeah.
I mean, that must be a reference to surplus activities. I
Yes.
accept it's cryptic, I accept it's not developed, but I don't think it's fair to say it's not there.
It's part of a history of, he says, it forms an integral part of a history of involvement with the PG7 movement, starting in Ethiopia and continuing in the UK. But there is no assertion in this skeleton argument, as far as I can see, that sur place activities of themselves, and I say the first tier judge considered this anyway, but for reasons set out in my skeleton argument, but there's no suggestion that sur place activities of themselves would result in mistreatment in this case. In the skeleton argument, that's an issue which the tribunal, one of the issues the tribunal will have to consider upon return, upon remittal, but and indeed there's no suggestion as to whether there is a discrete issue of suppression of political beliefs. Now, I say that's a matter for the tribunal to consider upon remittal, whether the determination is nevertheless flawed, despite the way the case was put by the FTTJ before the FTJ, and indeed they may well be assisted by submissions as to how it was put, because this is just a skeleton argument. There are, you do not, for obvious reasons, have what I believe is a very large bundle of documentary evidence that was before the first tier judge, and which included, as part of the appellant's evidence, the CPIN upon which UTJ Gleeson relied, and all of those matters are best assessed, the importance of them, in my submission, by the tribunal. I say this is certainly not a case where you should simply conclude that the first tier judge made an error of law. Whatever failings there were in the first, or may have been in the first tier judge's determination, there are obvious materiality issues given the comprehensive rejection of GA's credibility and the account which is summarised in the skeleton argument. And I say that materiality is best judged by the tribunal. In terms of whether you should make a direction that an oral hearing is necessary, well, in my respectful submission, you should simply do what happens in every other appeal. You quash the determination and you send it back. And in my understanding, the Court of Appeal does not ordinarily enter into such matters as mode of hearing. It does seem highly unlikely, not least due to the passage of time, that and the apparent change of practice. It seems highly unlikely that the UTJ would decide to determine this case on the papers, but there is no reason to restrict their discretion in that respect. No reason to suppose they wouldn't make a lawful determination. Thank you very much. Those are my submissions.
Anything else?
No, thank you.
Thank you very much, Mr. Wade. So who's going first in reply?
My Lord, we've agreed that I will go first, if that's convenient for you. My Lord, just starting with Mr. Waite's very helpful 7 or 9 issues, for which I'm grateful. Can I just say first that there's a large amount of agreement about the issues, but there are also some important disagreements. So in relation to issue 1, I agree that the key question when looking at what the upper tribunal judge has got to do when making the decision is to ask whether it's fair or not to dispense with an oral hearing. And I also agree that fairness depends on the circumstances. And finally, I agree that an oral hearing will not be required in every case as a matter of generality across the common law system. But my learned friend's submissions in relation to Ewing, in my respectful submission, highlighted some aspects of it which you respectfully should not follow, and other aspects which you should. So, for example, at paragraph 32, although he expressed it in terms of a difference between tribunals and the High Court, Mr. Justice Sullivan, as he then was recognising that there are important differences depending on the types of issues that are considered as to when and whether an oral hearing is required. And as far as his reference to Lord Justice Taylor's judgment from a 1992 case is concerned, in particular the suggestion that an oral hearing will usually only be required where there are substantial issues of fact, that's been superseded by Smith and West in the House of Lords and by Osborne, both of which judgments make it plain at paragraphs, and I'll just give you the references, 30 to 35.
I thought West was referred to in Ewing.
It was referred to in Ewing, but the point about Ewing is it was relying on I respectfully suggest another aspect of that judgment of Lord Justice Taylor, and of course Mr. Justice Sullivan, as he then was, couldn't have disapplied the findings in the House of Lords in West as to the relevance of issues of fact and disputes on fact for determining whether an oral hearing was required. And the House of Lords and the Supreme Court have made it absolutely clear, paragraphs 30 to 35, tab 47, that's West, 66 to 68 of Osborne, 74 to 75 of Osborne, tab 31, and 84 to 86, that while, of course, it is one factor as to when an oral hearing is required, it is not the only factor.
So what is one factor?
Whether there are significant issues of fact to be disputed areas of fact.
And one of the difficulties with this is using perfectly properly dicta in one area to another, because if you've got a parole hearing and the issue is, are you a risk, then to be honest, seeing you in front of me is quite important. Me saying, well, actually, I think you're a risk because you did this, and what do you say about that? It's par excellence, in some respects, for an oral hearing, which is all you've got in Smith and West and Osborne. You're right, they do lay down general principles, but it's not right to say that everything, therefore, needs to have a fair hearing, an oral hearing.
Well, I absolutely accept that. I'm relying on the general principles, but I'm simply saying what those general principles establish is that you cannot simply say, in relation to deciding when an oral hearing is required, well, it doesn't concern evidence or a disputed issue of fact.
And therefore, you take into account all the circumstances,
exactly,
which include
are
there any areas of fact?
Which
disputes of fact, I mean.
Yes, which any disputes of fact or issues of evidence, absolutely one factor, but there are other factors. And even Ewing is acknowledging that by talking about the High Court cases and judicial reviews, for example, where usually there aren't disputed areas of fact in judicial review. But the reality is that hearings are oral hearings in that context.
And the upper tribunal rules require those still to be hearings.
And require them still to be a hearing, exactly. But so what that means is that, of course, again, I accept that if it's an error of law hearing, that is one relevant feature of it when you're deciding whether an oral hearing is required. But in my respectful submission, to say that's the only important feature is contrary to Osborne and West. What matters, as all of those cases make clear, is that you take into account other issues, and predominantly in this jurisdiction, the importance of the case to the individuals concerned. Because in the end, if someone is, as a consequence of the decision, facing removal to a persecution or a splitting of their family, separation from their children, these are issues of fundamental importance that concern their human dignity, and in my respectful submission, it will be an unusual case that does not require a hearing in that context. And certainly it is a matter that has to be very carefully considered. So what is the right approach for a tribunal judge? They, when deciding whether to dispense with an oral hearing, they must, in my respectful submission, explicitly identify the factors they've considered and the factors that are relevant in favour of an oral hearing in an individual case, and that's likely to include, almost always going to include, the importance of the case to the individual in this jurisdiction. It's obviously a central factor. They'll have to identify that the highest standards of fairness are required in asylum and protection appeals, and anxious scrutiny or whatever variation of that term is appropriate to recognise the rights in issue, the dignity of the individual, and also, and this goes back to the President's own acceptance in JCWI, to acknowledge that in this particular jurisdiction, most cases are likely to require an oral hearing. That was accepted by the President in JCWI. And then, of course, an explanation if a paper determination is going to be adopted of why that is going to be fair in all the circumstances and what precautions will be taken. And these are significant decisions to dispense with an oral hearing. In my respectful submission, they've been submissions have been requested upon them, and careful decisions need to be taken. And the wrong approach, by contrast, is simply is to make brief reference to the overriding objective and simply say, oh, it's fair. I've considered all the circumstances, and in my view, it's fair. That's not enough. That's not the right approach.
Why is that not enough?
Well, because you've got to identify the factors that you've considered.
Why?
Well, I'm going to come on to partly because of the what my learned friend. I'm going to come on to his third issue, which was Iran. You've got to show that you have what matters you've taken into account, so it can be properly understood and challenged. Now, if these matters are relevant to your decision, as I suggest they are, you've got to identify them and say, at the very least, that you've considered them. Otherwise, nobody knows why you've taken the decision you have. I mean, that's what Iran says.
Comprises a number of factors.
Yes.
Why can't you simply refer to it and assume that those reading it understand that it comprises the factors listed in the CPR and in Rule 2?
Because how they operate when compared with the facts of your particular case is a central part of the reasoning that you will have taken into account when reaching your decision. I mean, unless you know how they've been...
several pages in many cases.
Well,
if you did.
It doesn't have to, in my respectful submission, it doesn't have to be several pages, it just can't be 2 lines. That's all I'm suggesting. An application of the principles to the facts of the individual case. Because as Mr. Justice Sullivan and all the other judges that have looked at this issue have established, what fairness requires depends on the circumstances. So you can't, on the one hand, say that fairness requires different things according to the circumstances. On the other hand, simply refer to the general principles without explaining how they apply to your particular circumstances. So that's my submission on issue 1. And I just remind the court about paragraph 6.16 of JCWI, which records the President's acceptance that the pandemic was not a sufficient basis for dispensing with oral hearings, nor in the normal course of events. Issue 2, what is this court's approach? Now, my learned friend accepted, and I agree, that the court must be satisfied the procedure is fair. And in my submission, that does involve the court assessing for itself whether it was fair in each case.
Are you talking about the Court of Appeal here?
Any court reviewing whether another decision maker or another court has acted lawfully doesn't do so on the judicial review reasonableness approach. It makes the assessment of fairness for itself.
But suppose we thought, for example, inadequate reasons had been given for the reasons you've given in one case, but actually it was a fair procedure. We would then be entitled to say it was a fair procedure. If there were inadequate, yes, I accept that you would be looking at it for yourselves. Yeah.
But obviously, if you decided that it was unfair, then for the reasons that we've already
unfair,
it has to go back unless
yeah.
Unless it's absolutely certain that it would be the same result. So that's issue 2. Issue 3 I agree. That was the
Sorry, can I just
Yes.
make sure I understand that? Unless absolutely certain it'd be the same result. I mean, in criminal jurisprudence, there's a line of authority that, fine, we'd have applied the proviso, but you haven't had a fair trial.
Yes.
You have to have a fair trial, and therefore we'd quash the conviction. You don't accept that for this jurisdiction, and you're saying that if we're sure it would be the
Well,
same.
no, the primary submission that I make in this, it doesn't apply in my particular case, but in the primary submission I make is that if it's unfair, it should be sent back for those reasons.
Thank you.
But there are some cases that suggest that, including SH Afghanistan, if it's absolutely inevitable, and you can see with hindsight in that case, there was a lot of water under the bridge.
Yeah.
You can see that the result would be the same. You don't have to. There's a split of authority. And in my respectful submission, the right approach is to when something is procedurally unfair, and particularly with an issue like this, it should be sent back for all the reasons that the case law identifies, including burning sense of injustice and that sort of consideration. So issue 3 was Iran. And I agree with my learned friend. Judgments must identify and record the matters critical to the decision so that it can be understood. And as I've already alluded to, that does mean, in my respectful submission, not simply identifying factors or saying I think it's fair, but explaining why. And Iran is clear that the judgment doesn't have to be absolutely word for word every matter that's been discussed. It's a pragmatic assessment of what's required, but something is required to explain your decision making in the particular case. Issues 4 and 5, the legal status of this is my learned friend's legal status of the the presidential guidance. I agree that there is no statutory requirement to follow it. I disagree that it's not a relevant consideration. It obviously is a relevant consideration. Parliament considered it necessary and desirable for Chamber Presidents to issue guidance on changes in the law and practice. And no doubt that was for a variety of reasons, including to ensure consistency of approach and to make sure that upper tribunal judges were up to date. And it is important to remember that there is a distinction in a status which is written into the Tribunal Courts and Enforcement Act. I don't think the relevant provision is in the bundle, but the Chamber President has to be a High Court judge, and that is not so of all the upper tribunal judges. And it's an important feature of why the upper tribunal and the first upper tribunal has the status that it does, as it was considered in the case of Cart in the Supreme Court. So I do say that it is clearly a relevant consideration, and that judges would generally be expected to follow it, and if they didn't follow it, to explain why not, and to have a good reason for not doing so. I also accept, of course, my Lord, the Master of the Rolls observation, it doesn't change the law. But if the guidance, for some reason, is wrong, and judges, as they are expected to do, follow it, they will make that mistake in law, about the law. That is the simple point, and it comes back to the question that arises in these cases: did the judge in question follow it or not? On issue 6, which is JCWI and the relevance of it, first of all, I agree that there's a level of agreement and disagreement. So first of all, it's important to recall there were 3 mistakes that the High Court found in the guidance. The first was that the guidance communicated a presumption, but there was no dispute that if the presumption was applied, it was unlawful. The second was that the guidance that importance without more could not on its own necessitate an oral hearing. That was found to be unlawful. Now that was disputed, but by the time of the hearing, it had largely been conceded. So the President accepted that in a contested case, a protection and asylum case, in a contested case, importance would be enough to justify an oral hearing unless it was obvious. So there was a large measure of agreement on that issue. And the third mistake was that the guidance should have set out the other factors that were relevant to the decision, given what it has said about factual matters and particular complexity.
Sorry, that last submission was?
So it's at 7.7 to 7, believe 7.15 of the judgment, the final mistake in the guidance, you see this at 8.1 in the summary, was that it failed to explicitly identify other factors that were relevant to the decision on whether an oral hearing would be fair or not. And overall, given that it had identified particular complexity and factual disputes or the need for evidence as a reason for an oral hearing, it gave the wrong overall impression. That was the third area of unlawfulness. Now, in my respectful submission, the findings on 1 and 3 are irrelevant to the question that you have to answer, because you will be looking as to whether a particular judge applied the presumption. And that doesn't, and I accept what my learned friend said, that doesn't depend on whether the guidance note communicated it or not explicitly. Either they considered, and in relation to the matters that were left out from the guidance, you're looking at the individual decision to see if the judges have taken those matters into account.
I'm not sure that that's consistent with your previous submission, which is that we're looking to see whether it's fair. Whether they've applied the presumption, whether they've not applied the presumption doesn't really matter. The question is whether it's fair.
Well, my lord...
I mean, obviously you say if they've applied the presumption, it might not be fair. But, I mean, you could have applied the presumption in a case where, frankly, it was perfectly fit for a paper determination. And on that analysis, it doesn't matter that they've applied the presumption. The question for us is whether it's fair.
Well, my lord, I do say it's relevant whether they've applied the presumption, because if they have, you've had an unfair hearing. So it's similar to the point...
No, because they've just decided to have a paper determination by a silly route.
Oh, I see. Yes, I see what you mean.
But actually, if you'd have applied the overriding objective, had regard to importance, burning senses of injustice and all the rest of it, would have been perfectly profitable to have that. And actually, you've had a fair determination, and that's enough.
Well, I accept that you could look at a case and decide for yourselves whether it was fair in circumstances where they had followed the presumption or made other errors of law.
Yeah, sorry to interrupt.
And I suppose the point about this is really, one has to be conscious of what the threshold is for getting to this court in the first place. We're in second appeals criteria.
Yeah.
And ordinarily, you wouldn't be permitted to come here to ask you to assess whether hearing is fair or not. But if, with these doubts about whether the presumption was or wasn't followed, and the unlawfulness of the guidance, I accept that this court could make a substantive assessment of whether it was fair or not. But it would have to have that, the appellants would have to have that opportunity, is really what I'm saying. And of course, it is difficult to do that in hindsight. I mean, that's the other factor. I mean, obviously, we're not discussing this in this case because it's accepted it was unfair. But it is difficult to do that in hindsight. So that's the only caveat that I would make about that. So I agree that, largely speaking, the question of whether or the guidance was or was not, the decision on the guidance was or was not correct in JCWI is not relevant. But it does have relevance in this sense, that it communicated a presumption. It's been interpreted to have done so, bearing in mind the audience. That was the conclusion. And even EP Albania, the tribunal approached it on that way. They simply said, as their reason for concluding judges had not made the error, that they didn't follow it. They didn't say that they that they didn't say, and take the point that my learned friend has taken, that judges might have understood it differently. That's a new approach. And in my respectful submission, my learned friend said it would be unsafe to assume they had understood it like Mr. Justice Fordham. Well, I put it the other way. It would be very unsafe to suggest that they didn't understand it in that way after the process of interpretation that he went through. That was, so in that sense, I do say that it has relevance. And of course, really, when it comes to assessing, the key issue is when it comes to assessing what does a decision look like which has followed the guidance. My learned friend suggested you're either looking for them to confirm they've followed the presumption, or you're looking for them to confirm that they haven't followed the presumption. But there's a massive group of cases in the middle. Now, Miss Upper Tribunal Judge Gleeson was unusual in having confirmed after the event that she had applied the presumption. But most judges have not said so either way. In my respectful submission, the sort of, in circumstances where judges would be expected to follow the guidance, you're looking for some indication that they haven't done so. And that would be for example, a detailed examination of the underlying reasons as to why an oral hearing would be required, or some other indication that they haven't followed the guidance or the presumption. But if there's nothing, and if there are very bare reasons, in my respectful submission, that is most consistent with applying the presumption, because that's what judges do when there's a presumption. They don't think it's necessary to give very many reasons. If, for example, somebody hasn't objected, they will simply say, well, I think no one has objected, so I'm going to follow the default position. That's what a presumption looks like in practice. So that is, so I don't, so it's in essence, I do say that JCWI has relevance, but it has relevance as largely as a factual finding which underlies the basis on which these applications are coming before the court, and also stimulates the question that the court has to ask about whether the unlawful approach to the law has been followed in each individual case. And my lord, my learned friend said that the figure of 60, it's in fact 66% heard on the papers in this period, could have been compatible with the overriding objective and with the practice direction, the senior president's practice direction. I don't accept that, and neither did the president himself, because, and you can see that at 515 of JCWI, because that would be these appeals normally heard on the papers, and the president accepted at as recorded at 5.15 JCWI that would not be consistent with the overriding objective in this jurisdiction. So coming to issue 7 and EP Albania. My lord, my learned friend has asked you and invited you to conclude that although you can't decide that he accepts, you can't decide the individual cases, but that you should approve the general approach. And in my respectful submission, you should be cautious about doing that, because the approach that is set out in the generic paragraphs has to be read together with what was actually done in the individual cases in order to understand precisely what the tribunal meant. And I did hand up this morning. The reason I did is not because I want to go through it at all, but just for your note. This is where you can find the reasoning in each individual case. as to dispensing with oral hearings. Now, what you will notice when you go to have a look at these decisions is that you can't, there's no record of the underlying reasoning of the upper tribunal judge. The facts of the case are not set out. And you'll also see that, I hope I haven't misrepresented the position when I say they didn't look at fairness for themselves. On the whole, the types of conclusions reached are, and you can see this on page 2 of the note, the conclusion she reached was a conclusion open to her. There's no error in that approach. It doesn't rest on any error of principle or error of law. That's the sort of reasoning, and it's rather different. And they also, you will see, uphold pretty bare decisions, in which they themselves describe as brief. And that approach is based on some of the reasoning in the generic section. So, for example, at paragraphs 50 to 52 of EP Albania, they say it's not necessary for judges to refer to all or any of the factors set out in section 6 of Mr. Justice Fordham's judgment. They say at paragraph 88 of EP Albania, the Supreme Court's judgment in Osborne concerned the parole board, a very different function, which is a point I know my Lord has put to me, but there are general principles in there that are of relevance, and they say failure to refer to it says little about whether the tribunal has directed itself properly. They also say at 50 to 51 it's not necessary to refer to the overriding objective or the SPT's practice direction or leading authority on the common law duty to act fairly. And so it's those sorts of statements, when you look at what they actually did, it comes to life. And in my respectful submission, those statements were wrong, and you can see why they were wrong when you see what they did in the individual cases. And so until you've actually got those individual cases in front of you, I would urge the court not to say that it was correctly decided on the general principles, because you, especially if you're given the conclusions that you may or may not be reaching in these cases, and I would suggest that better to set out, of course you will set out your own approach based on the arguments that you've heard in these cases, and that will be likely to impact on your judgment about what may or may not have gone wrong in EP Albania. But I would, in my submission, it would be dangerous to do more than that and approve a judgment, passages of a judgment in which in the individual cases themselves are likely to come before you. So that is EP Albania. The question of JCWI, I'm grateful for the indication in relation to whether you're going to that you're not at the moment inviting submissions on it. The only thing I would like to pick up on, my learned friend was asked about why he hadn't appealed. And I just want to emphasise there is a point in the skeleton argument that GA submitted on Monday. There is a case in the Court of Appeal called Wimpy, which confirms that non-parties can appeal.
In certain circumstances.
In certain circumstances, but certainly open to ask. I'm not suggesting, and in fact it's not as limited as you might think.
And also in the judgment, it does say the Secretary of State's aware. I mean, we've got those
You've
points.
got those points.
You've set them out in writing.
Yes, but I just wanted, it was just this point about not being a party. It is actually possible, theoretically, to appeal as a party, and the time to have done it would obviously have been quite a long time ago. So just turning now to GA. My Lord, it appears that my learned friend is now conceding that there are all the errors of law in the grounds 1, 2 and 3, and that the matter should not be sent back for another decision as to whether you should have an oral hearing or not. The final area of dispute, because just to emphasise, that was the issue that that remained live before
So we would,
came here.
if accepting the joint submissions, then just send it back in the usual way.
So, well, send it back in the usual way. In my respectful submission, this court should say that an oral hearing is required in this case, given the issues. And you don't need to put it in the order, but I think in my respectful submission, it should be in the judgment because of the factual issues that need now to be considered. But on that, can I just come to the question of whether you should send it back for another error of law hearing, as it were, or whether you should send it back remit it either to the upper tribunal or to the first tier tribunal to reconsider the appeal on the basis that there was an error of law. And in my respectful submission, it is clear there was an error of law. That is why we are having this discussion about the facts. The error of law was the failure, and that was the basis on which permission was granted. The error of law was the failure to consider whether whether GA was at risk based on his accepted membership of PG7 and his support of it. And that is why the Secretary of State made submissions that actually there was a change in country conditions, so that no longer, even that membership no longer put him at risk. Now that is the factual issue that has to be determined. And the obvious and only proper place for that is the first tier tribunal, or the upper tribunal retaining the appeal for itself.
Yeah.
And sorry.
Just in relation, we set aside the upper tribunal's decision. They
Yes.
then have to determine whether it's an error of law. You say that's a 5-minute exercise, and then they go and will then remake the decision, hearing evidence if necessary.
Well, my lord, I was inviting this court to determine that there was an error of law in the first tier tribunal's decision. But I think if it goes back for an oral hearing of the error of law and remaking, I'm not going to contest that approach.
Well, if we sent it back for an error of law, then plainly they would have to decide if there was an error of law, and you say it's obvious
Yes.
there was, whether to remake there or send it back to the FTT.
Yes. But that, obviously, my learned friend has just spent some of his submissions talking about how it would be necessary to look at the submissions, what submissions were made before the first tier tribunal judge, and the questions of fact, and review the AAR. It obviously needs an oral hearing, in my respectful submission.
Yep.
And I don't think that, of course, my learned friend says this is now the practice and so on, but given the history in this case, and given that we've pleaded the point, I invite you to make that clear, just for the avoidance of doubt, and I hope that that's not a disproportionate request in all the circumstances.
You say, given the history,
Yes.
that even though it's conceded that the overwhelming likelihood
Yes.
is that it would be an oral hearing, that it should be made clear either in a judgment or by direction that there will be an oral hearing.
Yes. Yes. Precisely. Unless there's anything else I can assist you with, those are my submissions.
Thank you very much, Ms. Kilburn. Mr. Lee.
My Lord, I will be quite brief. There's just a couple of matters I need to raise. The first is just in answer to my, or Justice Dingemans' question about relief.
Yeah.
Essentially, the first proposition is that we would ask for a quashing of Upper Tribunal Judge Hanson's decision that there's no error of law. So we would go back to the error of law stage. Obviously, again, taking Lady Justice King's point, in the particular circumstances of these appeals and given the history, if the court feels able to direct an oral hearing, although I do accept the general point that practice appears to change in any event. But so that's the relief that we would seek. There's been a division of labour between the appellants, as you would have seen. My learned friend, for obvious reasons, has done most of the work on the question of the influence or otherwise of JCWI and EP and the PGN on the overall fairness of proceeding. I'll just make a very specific point, if I may, without rehashing any of that, in respect of some submissions my learned friend made, and also in respect of this point about the availability or otherwise of video hearings. I probably was slightly unfair to the jurisdiction in an initial exchange with my lord when I described it as being exotic in February 2020. In fact, of course, the Immigration Chamber did utilise video hearings for quite some time before that, in particular in respect of bail hearings, with detainees appearing by video in order to participate in without having to be produced. And quite often they would be representing themselves. But also in terms of appeals from abroad. So video hearings were not exotic in that jurisdiction at the time. And my lady's formulation earlier, that the question about whether an oral hearing is necessary or desirable, that one takes into account all relevant factors, including whether there's factual disputes. All relevant factors in my submission in March, April, May 2020 would also have included the availability of a remote hearing, and the fact that that could mitigate some of the inherent disadvantages of having no oral hearing at all. And I won't cite it, my lord, in any length, but you have paragraph 6.1 to 6.10 of JCWI, which goes through all of the reasons why oral hearings are advantageous in many respects. And there's only two points I would cite in respect to this specific submission. The first is paragraph 6.13 of JCWI, it's tab 19, page 290. And it's just a quote from Lord Reid in Osborne, where he says, "It can be prudent for a court or tribunal to allow an oral hearing if it is in doubt whether to do so or not." And then at 6.16, Mr. Justice Fordham deals with the question of what he describes as COVID dilution, whether or not the particular circumstances of the pandemic changed the criteria or changed the equation. And what he says there was that had it not been conceded that the overall paper norm was in breach of the overriding objective generally, he would have had to have looked carefully at the availability of remote hearings and whether or not that was a factor that ought to have been taken into account in decision making. And he says that he again quotes Osborne and Lord Reid, paragraph 2.3. He just inserts the words into. He says, "I can see the description of a face-to-face encounter to put the case effectively." Osborne, paragraph 2.3, readily becomes a hearing to put the case effectively. So, as part of the analysis in any individual case about whether or not an oral hearing ought to be dispensed with, it's my submission that part and parcel of the factors that ought to be taken into account are the mitigatory measures that are available both on video and telephone. And the short point in respect of my case is that those submissions were specifically made throughout by counsel and weren't engaged with by the judge. So in his reasons for saying no, you can't have a hearing, he doesn't engage with the possibility of the third way, if I dare say that. That leads on to another question about EP, and again I'll take this very briefly. My Lord has the point, which I think is an important one, Lord Justice Dingemans made it again today, that the exercise that the Tribunal was doing in EP was a different exercise. It's a Rule 43 jurisdiction, and they very specifically divided the question of procedural irregularity and the outcome in the individual cases of unfairness. That is not the approach, obviously, that the court will take on appeal, but it does mean that there are limitations in terms of the utility of drawing from EP. And I make one point about Mr. Hussain. He has been, in my submission, simultaneously unlucky and lucky in the way things went for him in the court below. He's been unlucky because his case was subject to what, in my submission, was an unfair procedure. He had aspects of his case that weren't taken into account. And why he's lucky is he's in the position of being able to point to Upper Tribunal Judge Hanson's determination, point to the Annex A, and point to what's said in the opening paragraphs, and demonstrate that something has clearly gone wrong. Now, in a paper exercise, in a paper-based decision-making process, that won't always be possible. One can test that by positing a situation where Annex A isn't attached to the determination, and one's left to try and make the argument, well, there's no reference to the 2nd of April submissions in the ground. And my learned friend would quite rightly say, well, there's, that it may be so to read as a whole. It's only because of really the accident of that annex being placed in the determination that I'm able to positively point to clues around the process which demonstrates, in my submission, beyond doubt that it was unfair. So when one looks at what ought to happen in cases generally, it has to be borne in mind that if one takes the approach of the tribunal in EP, those sorts of things may well not be obvious. And I just adopt my learned friend's formulation of the really the paucity of some of the reasoning in individual cases as being, in my submission, problematic. In terms of what should the approach be, I obviously ask you to also approach the inferences that the tribunal and EP draw with some caution, essentially for the reasons that my learned friend set out in oral submissions and also in her skeleton. But I'm just in my skeleton, and I won't dwell on it, but I took the point about, in terms of when one's looking at a case where there's been no oral hearing and there's complaints of procedural irregularity, I've suggested there's a spectrum, essentially, of analysis, depending on the context of the case, and all cases are context specific. But at the end of the spectrum that I've identified is the judicial bias cases, Miller and Dixon being an example, where one doesn't really even look at the underlying individual fairness or unfairness of the case, because the problem is, in a sense, intangible. If there's apparent judicial bias, really you can't conduct a forensic analysis of what happened, even at a hearing, because it's just almost impossible for an appellant to be asked to show what went wrong. It's not of that. It's a category error. And then there's TN Vietnam, which was a case where cases under the DFT rules were, the DFT rules were considered to be systemically unfair. And what was said in that case is one does look for individual unfairness, but it is material that the courts in TN Vietnam, it's page 189 of the authorities bundle, paragraph 87, they did adopt the approach of Lord Justice Singh in the Court of Appeal in that case, which is that one bears in mind when one's looking at these sorts of cases, when one's looking at individual unfairness, that you bear in mind there's a systemic problem, and therefore there's a, as I said yesterday, a high index of suspicion.
That was a very polite way of saying uphold JCWI at the end of your submissions.
Well,
because to adopt that approach would require determining whether JCWI was rightly.
Well, and there's authority beyond JCWI for the proposition that, I mean, leaving JCWI to one side, what you have without doubt is a sea change in March 2020 from almost without fail oral hearings on a particular issue to 66% being dealt with another way. There are the whole host of arguments about that my Lord's heard over the last 2 days and seen in the paper applications that are waiting for this judgment. But really the point I'm making is that when one looks at Hussain is a very good example of how easily things can go wrong, where an advocate does not have the opportunity to address court. And if one is looking to draw general conclusions from that, one of them is that there should be a high index of suspicion where somebody says, I haven't had a fair hearing, I ought to have had an oral hearing. And the sort of forensic analysis, which I'll come on to in a moment, that Mr. Waite suggests in Mr. Hussain's case is simply not going to be open to many appellants for the reasons I've said. So there has to be, in my submission, a very large degree of caution when looking at the way EP approached it. And EP, essentially, the tribunal were looking for very strong evidence that there'd been an unfairness. And in my submission, that in that context is the wrong approach. There ought to be much more of a gimlet eye from the court. And then finally, if I may, Mr. Waite's essentially mounted a materiality challenge to my point about the 2nd of April grounds. As my Lord points out, that a kind of lawyerly analysis of where the grounds overlap with the other submissions it's not really to the point. These submissions, and I emphasise it again, were in response to directions that replaced an opportunity to address the court orally. So they were an opportunity they were the only opportunity for advocacy. And so what those submissions were intended to do was to make arguments based on the original grounds. I've taken, my lords and my lady, to 3 individual points in those grounds, which I say do not appear elsewhere. But even if Mr. Waite is correct, and one can sort of forensically pick apart and say that they overlap in different ways, the 16th of April reply is deliberately written by counsel to be read in conjunction with the 2nd of April submission. So if one says, well, you know, the 16th of April covers much the same ground, that's not what counsel had in mind, and it's clear that 2nd of April submission points the judge to different aspects of the evidence and different aspects of the argument which do not appear elsewhere. But also, there is no clue anywhere in Upper Tribunal Judge Hanson's determination that he has decided that the 2nd of April submissions don't add anything, that they're so OTOs that he needn't consider them. Had he said, well, I've looked at the 2nd of April decision and I prefer to concentrate on the grounds of appeal and the 16th of April submissions, then my argument would be different. But he hasn't done that. And so what my learned friend is really asking me to do is speculate about what he did. You have the point, well, about reading both the determination and Annex A, which is the directions together, which is a strong clue as to what happened in this case. And then very, very briefly, the last reference to authority, SH Afghanistan at tab 32, page 708 of the authority bundle. And beginning at paragraph 15.
So which page?
It's page 708 in particular.
Oh, 708.
So page 708, the passage begins in the page before, but the court is citing Crown on the application of, well, it's ex parte Kingdom of Belgium, which in turn, at paragraph 15, quotes the famous evocation of the essence of justice by McGarry J. in John and Rees. The point about the path of law being strewn with examples of open and shut cases which somehow were not. And in SH, the point was, as you see at paragraph 17, the question for the court was whether the evidence that the appellant is over 18 is so overwhelming that it's pointless to remit the matter to the first-tier tribunal, notwithstanding the errors of approach of both the first-tier tribunal and the upper tribunal, which I've identified. And then at paragraph 24, in my view, notwithstanding the errors I've identified, this is one of those rare cases which the unlawful errors of procedure made no difference whatever. Now in this case, that's essentially what you're being asked to find. But there's a subtle difference here. In that case, clearly there was an oral hearing. The evidence was overwhelming. And in this case, what's been missed out is essentially a whole set of evidence. And in my submission, it cannot be said that it's beyond doubt that a judge, having taken everything into account, could have come to a different conclusion. It's also contextually important to remember that there had already been a filter, there'd already been a judge who looked at the case and said it's arguable that the first-tier tribunal erred in law. So that's the context of all of that. I'll just finally finish, if I may, just by respectfully adopting my Lord Dingemans' approach, helpfully reminding us that it's helpful sometimes just to step back and see cases through the eyes of the actual individual, the actual appellant themselves. My Lord referred to the burning sense of injustice that someone might have felt in this situation. It has to be recalled that the journey that this appellant went on from the outset was originally he would have been told that he was going to have a hearing of this error of law appeal. He's then told that there's a difference in procedure because of the pandemic, and one can readily expect someone to understand that at that point, but that there will be a set of directions which are designed to mitigate, insofar as possible, any risk of injustice. He's then told that the judge hasn't got his 2nd of April submission, some of the key parts of his argument, but nonetheless, hopefully that will be rectified. He then reads the judge's determination, which makes no reference to them at all. Indeed, on any fair reading, appears to carry on with the impression that those submissions were never received. And then, on the permission to appeal application, he's told by the judge that everything was taken into account. And this is all in the context, of course, of a man who made an application under the regulations which now no longer exist. So he has no remedy. He cannot make another application because of the passage of time and the fact that the regulations have now been removed. So he's literally left pointing at an unfair procedure. And it's not so much a burning sense of justice at this stage in my submission as a positive inferno. And when one looks at the context of all of this in my submission, this clearly is a case which has gone badly wrong. Unless I can assist.
Thank you very much, Mr. Lee. Mr. Wade, do you want to come back on SH Afghanistan, Miller and Dixon, or TN Vietnam?
I don't think so.
Thank you very much. Well, in those circumstances, we will take time to consider our judgments, and we will hand them down in the usual way. And when we do, we'd be grateful if you would send us typographical but not other corrections, and also agree the consequential orders that flow from the judgments. And if you can't agree them, we'll deal with them in writing, but not in a hearing unless something very special happens. So thank you all very much for this interesting argument.